Hello, this is Alan Kato again. I am the owner and operator of my own legal practice here in San Francisco, advising employers in all aspects of employment law. And in this session of the program with respect to employee terminations and performance management, we will continue on with the aspects of what constitutes a sound performance management system. So in the previous aspect of this program, we talked about making sure to have facts in a performance review that support the conclusions that are stated in the review. And I gave some examples of what are good factual elements to support the conclusion. And I wanted to now explain a little bit further about why it's important to state facts rather than just having conclusions. And in the litigation context, which frankly is, for the most part, why we're doing all of this, which is to be able to defend against legal claims that the employee was wrongfully terminated or that the employee was discriminated against unlawfully, is that if you have a review that doesn't have facts in support but relies just on these conclusions, in my experience, and I've litigated employment cases for several decades now, the conclusions are going to be much less persuasive to a jury. And why I say that is that juries will view and may view these conclusions as, frankly, easier for a manager to make up compared to specific factual examples that may support the conclusion. And that these conclusions that are unsupported by facts are going to be easier for an employee to dispute in court and thereby avoid having a court dismiss the lawsuit by way of summary judgment, which I explained in the previous aspect of the program. And last but not least, without the underlying facts, a manager may not be able to remember all the facts that support the conclusion. Now, why I say this is that oftentimes it will be months, if not years, before the matter gets to a trial where a manager is going to have to testify in support of why he or she terminated the employee and to be able to defend the litigation on behalf of the employer. And in that type of a situation, without good records that, for instance, a performance review that states facts in support, the manager is just going to be, unfortunately, in many occasions, forgetful of what the basis of the negative performance review was. So let's move on then to the notion of progressive discipline. Now, what that means is, let's assume that we have given the employee a negative performance review, not quite negative enough to warrant immediate termination or even of going to a disciplinary step. But let's assume performance review was given with negative aspects of it, with an instruction that the employee needed to improve. And weeks or months later, the employee has been given an opportunity to turn things around, but that has not happened yet. And again, we're still not at the point where the employer is ready to just terminate the employee immediately. But we are ready, the employer is ready to take steps prior to termination to give the employee a firm warning about the continued existence of performance problems, to give that employee an opportunity to improve, specifically to turn these aspects of employment around, and to let the employee know that if he or she does not turn his or her performance around, then ultimately the employer is going to have no choice but to terminate that relationship. So in the context of a good progressive discipline system, the common elements are listed here. And I don't think that they're going to be much of a surprise to anyone in terms of generally starting with a verbal warning. Now, this would generally be documented in some form of confirmatory memo to the file, or at least to the HR or Human Resources file. Then, if the verbal warning doesn't do what it needs to do in terms of convincing the employee to turn his or her performance around, followed by a written warning that can be a performance improvement plan or just a separate step before a next step of a performance improvement plan, depending on the seriousness of the performance issue. There can next be a possible suspension of the employment as another element of progressive discipline. I want to say a little bit about suspension, and I don't think that this is also something that would be a surprise to anyone in terms of suspension as an element of a common progressive discipline system. I frankly, though, am not a fan of suspensions as a progressive discipline tool, except in pretty rare cases. And I say that except in the government sector or in a environment where you have employees who are unionized or in other blue-collar work environments. I would tend to believe that employers rarely use suspension as a form of progressive discipline. It would be rather my experience that after an employee fails to improve after a written warning or performance improvement plan, that most employers either would proceed to termination or perhaps to provide another written warning or performance improvement plan, depending on the circumstances. Now, having said that, I will say that a suspension may be appropriate in what I would call an unusual case in which the employee has engaged in significant misconduct. And the example I'd give of that would be a safety violation that perhaps warrants a particularly stern warning that is more than a written warning, but that does not quite warrant a termination. Now, if you're going to go ahead and use a suspension as a progressive discipline tool, I do recommend that it should be accompanied by a detailed written warning explaining the reasons for and the details of the suspension and what is expected of the employee in the future. And before suspending an employee, especially without pay, I think that would be fairly common. If you're going to suspend, it would be without pay. An employer should consult with its legal counsel to ensure that the company complies with respect to the requirements of the Federal Fair Labor Standards Act and state law, applicable state law, to provide a guaranteed weekly salary for any week in which an employee performs any work, if this involves an employee who is exempt from overtime. Now, having said all this about this notion about progressive discipline, I don't want to forget the notion that the process of progressive discipline is not necessarily required by law unless you have an agreement, a legally enforceable agreement that requires progressive discipline, or, for instance, in the context of a government civil service employment relationship, or you have an employee who is covered by a union collective bargaining agreement that requires progressive discipline. So you may be asking then, well, why are we still doing progressive discipline or talking about progressive discipline? Well, I've listed several concepts that I believe support the notion that in many situations, because you're not going to use progressive discipline, frankly, in all situations, but in many, and in fact perhaps most situations, the employer should at least consider applying these progressive discipline steps. First of all, the practical and the legal benefit of engaging in a sound progressive discipline performance management system is that it shows to the employee that you, the employer, are dealing with him fairly and in good faith. And by doing that, it creates evidence on behalf of the employer to support your defense should this matter turn into a litigation matter, that the employee was treated fairly. And at the end of the day, most juries are going to be looking at that and assessing wrongful termination cases based upon notions of fairness like this. Secondly, you'll be able to create a paper record that is consistent with your concerns about performance. And again, in the litigation context, after many, many years of litigating these cases, a good documentary trail of records is frankly going to be believed by a court or a jury much more than the contrary verbal testimony of an employee, so long as you have good documentation that was created at the time over the course of the employment relationship. And the other thing that the progressive discipline will do is, you remember in an earlier session, one scenario where a manager has not done a good job of performance management, has had an employee who was not a good performer for perhaps several years, and now the manager is sick and tired of this poor performing employee and wants to terminate the employee now. But when we look back into the into the personnel file as well as other documentation of the relationship, that personnel file and the other records establish nothing but good performance reviews and other indicia of positive performance by the employee, such that there is no support for the notion that this employee was a poor performer. Well, even in that sort of a setting, this is the opportunity by using the progressive discipline system to, and I emphasize this point, to reset and reverse prior documentation that the employee was a good performer by documenting that now this employee is not a good performer and needs to turn the performance around in order to continue to be employed. So the good documentation, the records of good performance in the past, that was before. But now the fact is that the employee is not performing to a level that satisfies the employer, and he or she needs to turn that performance around. And this is what the progressive discipline process will enable the employer to accomplish. Now, a good example of how good documentation can save an employer, frankly, was a recent case called Cont'd versus Steele case that was decided by the Federal First Circuit in January of this year, 2014. So Ms. Cont'd was an area manager for her employer Steele case, and what that meant was that she was the liaison between the employer and the employer's dealers who sold the Steele case office products. Now, she had come forward and alleged that she was sexually harassed by her supervisor, and later the employer fired her. She brought a lawsuit claiming that she was fired in retaliation for her earlier complaint about sexual harassment by her supervisor. However, the employer won the case. How did the employer do that? Well, first, the employer submitted documented evidence of performance problems. That documentation was created before any complaint of sexual harassment had been made by the employee. Second, she had been given a negative performance review giving her 1 month to improve her performance, and that she was terminated after this 1 month performance improvement plan. And during that month, the employee had made a serious mistake by sending inaccurate information to a dealer, resulting in a dealer complaint about this employee. So in that type of a situation, the employer, with this good documentation, was able to prevail in the litigation, and the employee lost her lawsuit. It was dismissed without further ado. So I think one of the other points I wanted to make about this whole notion of progressive discipline is that in most cases, in my experience, I think I hear this a lot from my clients and the human resources professionals who are my contact with the client, that their greatest challenge is often to convince and prod their managers to generate any such documentation that would support the performance issues on behalf of the employee. Now, switching gears on this, on some rare occasions, employers can also do itself harm through overzealous performance documentation. Now, this can happen when a manager decides that he or she wants to terminate an employee for poor performance and thinks, gee, the more documentation, the better. Now, sometimes this results in a manager creating an inordinate amount of documentation concerning an employee, as to suggest that the manager may have been out to get that employee. So to avoid that type of a scenario, it's important for a company and its HR professionals to train their managers to be reasonable as to the amount of documentation that they generate. It would be my view that an overly generous amount of documents that are nitpicking, I guess is the best way to describe that, nitpicking an employee's performance, may seem to a jury or a judge artificial and unreasonable, and cause that jury or the judge to wonder whether there is perhaps an ulterior motive behind the seemingly excessive documentation. In short, these managers should be trained, and the personnel records should be reviewed by human resources to ensure that the documentation will not appear to be artificial and trumped up. So the slide mentions that one limitation that I would put on the use of progressive discipline is to use the process only when it makes sense and would support what I refer to as this fairness defense. Now, a recent example of this was a decision by a California Court of Appeal in a case called Cheel versus El Camino Hospital that was decided in January of this year, 2014. Ms. Cheel was a dietetic technician who was fired for poor performance related to her job, which was to prepare menus for the patients in the hospital. Now, the employer, in its defense of the lawsuit, had relied on some 16 written coachings by the supervisor. Now, in reversing a summary judgment dismissing the employee's lawsuit and requiring this matter to be tried and decided by a jury, the court observed that these coachings, and this is a quote, could be easily viewed by a jury as so trivial that their recordation was more suggestive of persecution than that of anything resembling legitimate concern with her performance. Now, the example given by the court was that one of the coachings or warnings by the supervisor was an instance where the technician had prepared a menu for a patient, and it was soiled because of a food stain. So that was an example of nitpicking by the supervisor about the employee's performance that didn't actually support the employer's case, but actually gave pause to the judge or the appellate court in this instance to suspect that this type of nitpicking for minor violations of rules and procedures just lent itself to the notion that this was more persecution rather than legitimate concern with the employee's performance. So the lesson to be drawn from that is that you should use performance management, such as warnings and performance improvement plans, for appropriate situations where there have been violations that would warrant this type of warnings that may lead up to termination. Now, there are going to be situations where progressive discipline, frankly, doesn't make sense. And it would be better in that situation, and this is the second bullet on this slide, it would be better to just proceed directly to termination. And this would be the case where you have, for instance, serious misconduct. What do I mean by that? Well, let's say that the employee has punched out his or her supervisor. Well, I'm sorry, but that's a violation of rules of any workplace, and in fact of any notion of living in a civilized society. We don't allow the employee to punch out the supervisor, and you certainly don't give the employee a second chance in that type of a situation by giving a warning and allowing the employee to punch out the supervisor a second time before he or she can be expected to be terminated. No, that would be warranting immediate termination. Another example that I've listed here, and this is not the only examples, but progressive discipline isn't warranted where you have what I refer to as a bad hire. And what I mean by that, as I explain here, is let's assume that there is just clear and unmistakable evidence that this employee lacks the qualification. It's not even close. The employee simply cannot do the job. Maybe there was an exaggeration in his or her resume about his or her qualifications that led to the hire. So in that type of a situation, putting the employee on a performance improvement plan, there's no reasonable expectation that the employee can turn around and improve during the PIP. And in that type of a situation, it is simply best to just go to immediate termination. All right, so I trust that all of you have either provided in your participation in this program, or I can certainly provide you with a sample template that I have available for a performance improvement plan. And even if you don't have the template, I think it's fairly straightforward that the template should just include these, what I refer to as the key components. And the key part of this, of course, is that if the employee doesn't turn around on the performance objectives and issues that are identified, that the consequence is that the employee may face further discipline up to and including immediate termination without further opportunity or notice to improve. Now, I state here a question. It's not uncommon to have, in the back end of the performance improvement plan, and you'll see that in my sample template. And by the way, if you don't have that and want a copy, you'll see that my contact information is provided as part of the materials. Just send me an email or call me, and I'd be happy to send you the template. But you'll see in that template that there's going to be towards the end an aspect there of having the employee sign and of even making comments if desired. Now, let's say that you have you've provided the employee with a written copy of the performance improvement plan, and the employee just simply refuses to sign. And what do you do about that? Well, first of all, the notion of employee having to sign is that you want them to acknowledge that they actually received a copy of the performance improvement plan. The whole idea why we do this is, for one, to give the employee notice of unsatisfactory performance and what he or she has to do to turn the performance around. So if the employee refuses to sign, it's often the case that the employee doesn't want to sign because he or she thinks that if he signs, then he is agreeing with what the employer has stated as performance deficiencies in the performance evaluation. Now, you can explain to the employee, well, that's not the case. You're only acknowledging receipt of the performance improvement plan, not that you necessarily agree with what is written about your performance in the PIP. So nonetheless, employees will fairly commonly refuse to sign the document. Now, first of all, at that point, when you're at loggerheads with the employee, I do not suggest that you try to force the employee to sign the performance improvement plan. It's not legally necessary. Legally, the employer does need to be able to establish that the PIP was delivered. Now, you can establish that in a court or other legal proceeding by either showing that the employee signed, acknowledging receipt, or, as a variation of that, just have the manager who was given the task of delivering the PIP to the employee, of handwriting, after, of course, handing the PIP to the employee, of handwriting a note that it was indeed handed to the employee on such and such a date, but but the employee refused to sign the acknowledgement, and just have the manager sign. So whether or not the employee signs on that occasion, the PIP has already fulfilled its legal purpose of giving that employee notice of the performance deficiencies and providing him or her an opportunity to improve. So at this point, we will sign off and resume in the next session.